Webinar where we will be looking at redundancies and restructures. This is part one of two parts, and the second will be taking place on the 14th of October. So just a bit of housekeeping before we get going. So the webinar is being recorded, as you'll probably see, and it will be circulated after. Please ensure you mute yourselves during the presentation, but if you do have questions, there is time at the end. So you can either unmute yourselves to ask us the question or feel free to pop it in the chat box. Just ensure that the chat box it is public. So if it is a confidential question or it's quite specific, you might feel better emailing Michael or I afterwards. So the introductions, my name is Simran Lalli and I'm an employment solicitor at Grant Saw. I am based in the Greenwich office. So I work with our head of department, Michael Pope, who is also presenting today, and paralegal Lauren Smith. In terms of the work that we do for employers, so we advise on both contentious and non-contentious employment law and HR matters. This does include defending employment tribunal claims, advising on redundancies and restructures, and TUPE. We advise on disciplinary and performance management matters, contracts of employment, staff handbooks, and policies. So today's webinar is part of a wider series of webinars that we have been holding over the summer and goes on to the end of the year. The aim is to keep you all up to date with the changing world of employment law and ensure that you're well equipped as business leaders and HR professionals for all eventualities. Our previous two webinars were based on long COVID in the workplace, where we were talking about the Equality Act and whether it amounted to a disability. And we also have done one on a fair recruitment process. If you missed those for any reason, do just let us know if you want a recording and we can share that with you. So I'll let Michael now introduce himself.
Thank you, Simran. Good afternoon, everybody. I'm Michael Pope. I'm a consultant solicitor in the employment department at Grant Saw, and over the many years of my career, I have done quite a lot of redundancies, advising clients on consultation procedures and all the other aspects of redundancies. And today I am going to talk about the redundancy consultation requirements. So we will start off talking about the formality of the collective consultation process. That's where 20 or more employees are going to be made redundant within a period of 90 days. It's a statutory consultation procedure, which means that there are strict rules to be followed. The history of it is that it's been in UK law for a very long time, since the 1970s. It was part of the European legislation since the early 90s, and although that legislation, as you know, is no longer part of our law, we are still bound by the same rules. They've been brought across into English law to ensure the same processes continue on as they have done up to now. So the question is whether or not you are looking at a one establishment. That it doesn't necessarily mean one building or just one workplace. It can mean, for example, in the case of retail outlets where there are a number of shops, it could mean that those shops can be added together to bring the numbers up to the required amount. If the management of the shops, the central administration, is effectively from one place. Also, quite strikingly, if you are part of a group of companies, then each employer company is treated separately for the purpose of calculating the numbers, which leads to the rather odd sort of loophole situation, I suppose you'd see it, that you could have 19 people working for one group company alongside in the same place as 19 people from another group company, and that total number would not equate to bringing the legislation into play because the employees were in separate companies. When should you start the process? Well, the answer to that is that at the point where redundancies are being seriously contemplated, but before a final decision is made. That's a difficult line to draw. because employers obviously need certainty, and very often the decision will be made in principle, but the requirement is that there is still time for a process of consultation about whether or not redundancies go ahead, and if so, how you go about it. Once that process is in play, then there is a requirement that no action should be taken in terms of terminating employment until the end of a period of 30 days if it's 20 or more employees, and a period of 45 days if there are 100 or more proposed redundancies. Now, that doesn't actually stop the employer giving notice during that period, but it would normally be unwise to do so because of the concern that the employer had made its mind up before the consultation process had been completed. What do you talk about? What's the purpose of the consultation process? Well, there are three core elements to it. The first thing is to try to avoid the redundancies altogether. And that obviously will entail a discussion about reducing working hours, if that's feasible, a possible freeze on recruitment, maybe adjustments to pay, maybe selling off part of the business if it's not profitable, maybe trying to get new investment, maybe a change in working methods, all of those things. In reality, of course, the employer will probably have looked at all of those options before getting to the point of deciding to go for redundancies, but they are on the table, and they can be consulted about with the employees, depending on the extent to which the employees in the consultation want to go there, want to engage in that. And then the second objective really is just a scaled down version of that, and that is not avoiding the redundancies altogether, but reducing the number of employees to be dismissed. If that can be done, again, it will be those same issues that might change the picture. And the third situation, which is much more obviously what the redundancy consultation is going to be about, is the way in which the redundancies in fact are implemented. Now, that could mean timing, deferring the redundancies or some of them. It could mean a discussion about what the financial package will be for people being made redundant, whether, for example, there will be enhanced packages over and above the statutory scheme and basic entitlement. So going on to the question of who do you consult with as the employer, the answer is affected employees, and that does not just mean those who are considered to be at risk, but also employees who are impacted by the proposed redundancies. So that will be people whose jobs may be affected when the other people leave. We are looking in those cases not necessarily at formal changes to the remaining workers' contracts, although Simran will tell you something about that in a few minutes, but also lesser measures, for example, where workload simply increase, people stay in the same job, but they are impacted by the fact that there are less people to do the work. Who do you consult with? It's on behalf of these affected employees. Well, you must consult with the trade union if a trade union is recognised for collective bargaining purposes in a particular bargaining unit, and if that's the case, then all of the employees in that bargaining unit, whether they're members of the union or not, will be represented by the trade union. A second option then, or the first option rather, if there is no trade union, is a standing body of employees, employee representatives. That would be something like a works council or forum, but caution with that, because it is important that that body is elected for the purpose of this particular consultation, or rather that when it was elected, its powers extended to, its authority extended to being able to consult on redundancies. And it's important to bear in mind that it must remain representative. So if employees, as they will of course come and go, If the body was elected or appointed some time ago, then the question will be whether or not it's truly representative of the existing workforce, and caution needs to be had there. The safer course in that situation and in all other situations is to elect employee representatives to have the consultation with the employer. Election means election, a formal election. How you go about it is to decide how many employee representatives you need. That will depend really on the size of your workforce who are being made redundant or affected by the redundancies, and also geographical issues. You need to have people elected who are going to be able to represent the people that are being affected by the redundancies. So if you've got different offices within your one establishment, then you might want a representative from each one of those. You can have people nominated, and there's no need for a vote if the number of nominations is equivalent to the number of people that you want to appoint. So if you want to appoint 3 representatives and there are only 3 nominations, then those 3 people will be elected. If you do have to go to a full vote, then many employers will think about bringing in an independent body to scrutinise that. And the rules are that it needs to be a secret ballot, and that there must be obviously fair processes and accurate counting. Once the employee representatives are in place, then they must be given a list of information relating to the proposed redundancies, which we call the statutory information, and that will then start the process. That is day 1 of the 30-day moratorium, the 45-day moratorium if the numbers are over 100. The information is the number of proposed redundancies, where they're going to be drawn from, what parts of the business, how the employer is going to go about selecting the employees. Those are very important issues, the selection criteria, how the selection tools are going to be devised, whether the employer is going to give notice to employees or whether they're going to go with a payment in lieu of notice, and how the redundancy payments are going to be calculated. As I said earlier, it may be that employers will in many cases come to some agreement with the representatives on an enhanced package over and above the statutory and contractual minimum. It's important to remember that the representatives are representatives, and that means they must have a mechanism by which they can consult with their constituents, if you want to call them that. That means that they need to have facilities. Ordinarily, there'll probably be a designated room. It will be open to the representatives to take the time off, take time out of their normal duties to meet with the employees affected. Some employers will go as far as to give separate email addresses to the representatives to make sure that there's no privacy issues and so on. So they're all set up to consult in that way. What can go wrong? Well, if you fail to follow the regulations, then there are significant financial penalties. The award of compensation is a maximum of 90 days uncapped pay when you think about the numbers of people who are potentially entitled to that sum. If the consultation procedure has not been properly followed, then the numbers are going to add up to a very significant amount, and it is very important that people take advice on how to go about these procedures. It's not necessarily 90 days, I should say. It depends on the tribunal's view of the failure of the employer to consult in the right way. It may only be a nominal amount at the end of the day if there's a technical breach, but if there's a failure to consult at all, or an obvious intention to get around the regulations, to ignore the regulations, then the likelihood is that the compensation will be at the higher end of the scale. It'll only be payable to those employees who apply. but if there is a feeling of strong disillusionment with the way the process has been carried out, then it's quite possible that the employees will be garnered together and will bring claims. So it's important to be aware of that financial penalty. It's a requirement with a statutory consultation that the employer must notify BEIS, that's the Business, Energy and Industrial Strategy Department. If you fail to do that, it's a criminal offence. And there is a defence to this, or to a failure to consult, which is that it was not practicable to do so, or at least not practicable to do all of the steps required. But in those circumstances, it's necessary to show that the employer did all that it could. But it's a very high standard, this, and even in the pandemic, it's going to be very difficult, and has been very difficult, for employers to argue that they couldn't carry on the process one way or the other for the minimum statutory periods. And also, failure to follow the consultation process is likely to feed into claims for unfair dismissal, whether they're direct dismissal or whether they're constructive dismissal claims. So if the employer does not need to consult through the statutory process because the numbers are less than the minimums, then direct consultation with the employees is still required. That's required as part of the general body of unfair dismissal law. It's a requirement to get a fair redundancy that there is a consultation with those people who are being made redundant. It's important, therefore, to get everybody who is at risk or affected by the redundancies into the process, which means making sure that people who are on leave, or who are on long-term sick, or who are on pregnancy or maternity absence, those people should be notified and allowed to consult, or allowed to participate in the consultation to the extent that they want to do so. What are you going to talk about? Well, very much the same things. It's still a question of, can the redundancies be avoided? If they can't, what steps are going to be taken in terms of the financial package, and so on. And it will normally be done by meetings, by group meetings, but a good technique I find in these circumstances is to produce an FAQ document which sets out all the sorts of questions that you'd expect the employees to ask and what the employer intends to do, and then to have the follow-up meetings so that everybody is informed. You may only need 1 or 2 meetings. It's not quite the same as the statutory process, but it's important that there is time allowed to bring out all the issues that need to be considered, and time for people to consider what's being said to them. At the end of the process, whether this is a statutory or whether it's a direct consultation, it's important that there's an individual consultation with each person who's being made redundant. The purpose of that is to see whether or not there is anything in particular about that person's circumstances which would constitute a real hardship on them if they were made redundant. But that is a very high standard, because redundancy is, of course, a hardship in itself, but that in itself will not be sufficient to stop a person from being made redundant. What is required is something very much more unusual, might be a terminal illness in the family or something of that kind. Something that comes up in most of these meetings is the question of the redundancy scoring. I recommend that the person who did the scoring should be present at the meeting so that the individual can ask questions about their score, but they're not entitled to see the scores of other people. That often causes some concern, because they say, well, the employer will say, well, very difficult for me to know whether I've been fairly scored if I don't know how other people were scored, but that isn't something that they are permitted to do. We recommend also that the employer allow the employee to be accompanied to that meeting, although there's no statutory requirement. It's not the same as a disciplinary or a grievance meeting, but if somebody is with them, then it enhances the feeling that the employees' concerns are being properly catered for. How do you go about the consultation exercise? Well, I always recommend setting out a timetable at the beginning to say what's going to happen, how many meetings you're going to have, possibly in the space of a month, 3 or 4, what's going to happen at each one. You can designate what each one is intended to achieve, although of course you'll need to be flexible if new things come up. Always have an agenda for each meeting. If the employees come up with proposals which they say would change the position, they must always be evaluated. They should always be taken away by the employer and considered before they give a response, even if it will be fairly obvious to the management team that there's no real scope to go along with it. And the employer can, during the course of the process, develop its case, listening to the arguments, providing information, and it may be that it'll be a detailed discussion about finances and that sort of thing. It isn't always, but it's important that the employer does answer specific questions as best it can, because that's a requirement of the process. And then the evidence gathering, always minute everything and keep copies of emails and correspondence of that kind, because it's remarkable how easy it is to lose things, or hard to gather it all together if you do get to the point of having to justify your actions to a tribunal. So what happens if you don't get to a landing, an agreement with the representatives? Well, I think the important thing is to make sure you're just clear about where you've ended up, and that each party's position is set out clearly, so you know why it broke down. At that point, the employer will most probably go ahead and make the redundancies. There's nothing to stop an employer from doing that if agreement is not reached, so long as it's gone about the consultation with a view to trying to reach the agreement, then it has met its legal requirements. It may do something else. It may call for volunteers to see what the response to that is. It may decide not to go ahead on this occasion, to wait to see if things change economically, but that would be unusual. I mean, you will have been through a longish consultation process, and I don't suppose there'd be a huge appetite for doing that again, but it's a possibility. Another possibility, which happens not infrequently, is that an employer will then start to approach employees individually and offer them settlement agreements, and that is covered by a confidentiality arrangement. It's called a protected conversation. And in those circumstances, it may be that over time the numbers will be brought down to a level that the employer is happy to go forward with. So that's an overview of the consultation process. I am now going to hand back to Simran, who's going to take you through her part of the presentation.
Thank you, Mike. So I'm changing employment terms. It can be quite a complex area. It does sometimes cause problems as you are balancing the rights of the employee as well as the needs of your own business. So the changes can be discrete and quite specific. They can include things like changing pay rates, bonus and commission structures, restrictive covenants, and the location of work. And we've seen some of these changes come about because of the pandemic. So if a proposed change impacts the employment contract of the employee, as an employer, the first thing you should really do is check if the terms of their contract authorise the change. This usually arises in 3 different ways. So it can be possible to interpret a term in question sufficiently broadly to accommodate the change that you're trying to make. There might be actually an express right in the contract to make that change. It could be a specific flexibility clause that you have in the contract. Or finally, it could be a more general flexibility clause that gives you the right to vary the terms, like a general power. So a change authorised by the contract is not, strictly speaking, a variation, but such a right has to be exercised carefully and it's still subject to a reasonableness test. So even if you do find that clause in the contract, it may not always be wise to rely on it in the case of varying pay. There is a likelihood that this could be a breach of the implied term of trust and confidence for the employee, and it could result in them resigning and claiming constructive dismissal if they do have the qualifying period of service, which is 2 years. So in terms of your options to change employment terms, there are a few. Number one being seeking the agreement of the employee and dismissing them if they refuse to agree. Number two is imposing the change and leaving it to the employees to decide how to respond, so that's unilaterally imposing the change. And then number three, which I'm sure you've heard of, is the terminate the existing employment contract and offer re-engagement on the new terms, which is now really known as fire and rehire. Looking at each one individually, so the ideal way we would say of making contractual changes is with the employee's consent. So hopefully by this route there is unlikely to be disputes in the future if it is carried out correctly. So the best way to do this is to enter into a reasonable consultation with the employee or their trade union representative or their elected employee representative. As Michael spoke about earlier, there is requirements for consultations. If you are proposing changes for 20 or more employees, then you will have to do a collective consultation, and as Michael said, there's specific rules for that. But in both individual cases and collective consultation, the discussions that you're having with the employee should really involve the reasons for the change, how it will affect them, and the consequences of them failing to agree to it. As an employer, you must negotiate in good faith, take into account the points raised by the employees as emphasised with the redundancies, and look at alternative and options to the proposed change. So as an employer, if you are trying to get an agreement to these changes, you are essentially undertaking a bit of a selling exercise where you should be looking for ways in which you could induce the employees or give them an incentive to accept the change, even if there is a detriment to them. So with contract law in England and Wales, it does require any agreed variation to a contract to be supported by consideration. So this does mean that there must be some form of benefit passing from employer to employee. If there is an inducement for the employee, such as a bonus or a pay rise being offered, that will be consideration. There might be innovative ways you can induce an employee to agree the change. It doesn't always have to be a financial incentive like pay or a bonus. The absence of consideration for a change may not always be an issue. Such consideration can sometimes be found in the employee just essentially having continued employment. And the courts have looked at this previously, and the approach that they previously have taken is that it's a common sense result. So in terms of the consultation, as we said, you explain the nature and the proposed timing of the change, as well as your business reason for the change. You should be drawing out any potential benefits for the employees and making clear of the likely implications for the business if the change is not implemented. If an agreement is reached at the end of that, then, as Michael was saying earlier, ensure that everything is recorded in writing, so there's minutes of the meeting, and ensure that the actual agreement is in writing as well. It should be within 1 month of the change taking effect, but we would advise that it's sooner rather than later anyway. And just as a side note, whilst we're talking about consultation, so if you are proposing to change the employees' benefits, pension benefits, then there are separate rules for that, and there's separate obligations under the Pensions Act 2004. So it's always worth seeking advice if you are proposing this change. So the second option is unilateral imposition of the change. So if there isn't a variation clause to rely on and you aren't able to get the employee's agreement, one option is to impose that change unilaterally. However, this is a breach of contract, and there are a number of ways an employee can react to this or respond to this. So they could expressly accept the change. In this situation, you will need to demonstrate that there has been adequate consideration, as I mentioned earlier. And again, the change will need to be documented in writing as soon as possible, but always within 1 month of the change. The employee could impliedly accept the change by just continuing to work under the now revised terms. This could, however, lead to a dispute maybe later down the line as to whether they actually agreed it or not, and whether their continued employment definitely amounted to acceptance of the term. With terms that don't actually impact employees until later, so an example being a reduced long service benefit, there's a lot more, it's a bit more unclear if they have accepted it because the benefit doesn't come into play until later. This is different to more immediate benefits such as a reduction in pay or commission or varied hours. Next, the employee could just refuse to work on the new terms, for example, by continuing to turn up to work at their old hours or even their old place of work if you're trying to change their location. It's then for you as an employer to decide what you do next. You could commence a disciplinary process if that's appropriate with the employee regarding their refusal to work under their new terms. The employee could continue to work, but they could make clear and expressly state that they're doing so under protest. They may then choose to bring a claim, so for breach of contract or unauthorised deduction from wages whilst they remain employed. So this is often referred to as the stand and sue approach. So they remain employed throughout, but they are pursuing a claim against you. And if the change is significant enough, the employee could assert that they were constructively dismissed. As I said, you need 2 years service for this type of claim. And there is a higher risk of this usually where the employee is demoted or their pay has significantly been reduced or they're on wholly different terms to what they were on previously. And then the employee could refuse the change and again assert constructive dismissal with claims for unfair dismissal and wrongful dismissal potentially following. The employee's chance of success with claims like this does really depend on the severity of the change that the employer is proposing to make, the wider circumstances of the employer, and whether you as employers did attempt to agree a change before it was unilaterally enforced. So this goes back to the topic of consultation. So did you try and reach an agreement before you took this course of action? And then we move on to the fire and rehire approach. So this is where an employer dismisses an employee, but does re-offer them and re-engages them on the new terms. So this practice has been kind of widely publicised recently, particularly in light of the pandemic. It isn't unlawful if you do carry it out properly. It has attracted some criticism recently with Unite and the TUC both calling for it to be completely banned. ACAS did a really interesting publication on this, so if you do have time or you are considering this approach, it is definitely worth having a read of that. Despite the criticisms that it has received, as I said, it's not actually unlawful provided you do take a reasonable process and carry it out properly. The process can be risky. Not only can it expose you as employers to claims against from the employee, but you should also be aware there can be possible reputational damage and it can impact employee relations, and as some companies have recently experienced, it can have the potential for industrial action. So this isn't a course of action we would advise embarking on without careful planning. You should be clear about why you're making the changes and be sure that you can always justify this to your employees. So if you are going down this route and you will be dismissing employees, you always need a fair reason to dismiss. And in most cases, employers will rely on the some other substantial reason approach. So this will be a sound business need to justify the dismissal. So that's why it's important that you've documented what is the reason for the change that you were proposing. You always need to follow a fair process as an employer. So this will involve, as we mentioned earlier, properly consulting with the affected employees about the proposed change, listen to them about their concerns, provide them with information about why the change is needed, and explain the potential alternatives if an agreement cannot be reached. For example, if the alternative is that the business will then restructure or commence redundancies, this should be notified to the employees and properly explained. So in terms of the criticisms about this approach, a lot of it was to do with employers using it as more of a threat or a negotiating tactic to force the change. The government's message in response to this is that all options to save jobs should be considered before considering dismissal and re-engagement. So they're essentially saying this is a last resort approach and you should exhaust all other options or at least consider them before you go down this route. So if you do ultimately end up dismissing an employee by this method, you should ensure that the employee is given their correct notice, and the new terms of the contract or the new contract only comes into effect immediately after the original contract for the employee has come to an end. So really, this is quite a complex way of changing terms and conditions in terms of the exposure to employment claims. So the best option will often depend on the business in question, the number of employees who will be subject to the change, and of course what the change is. It's not a one-size-fits-all approach, so a well-constructed action plan is needed for this way, and we would say that you do seek legal advice before commencing this process. Just as a side note, where we were talking about employment claims, so of course unfair dismissal, wrongful dismissal are the kind of usual ones, but it is important to also be mindful of the Equality Act here when making changes to employment terms. So if there is a term which you're proposing to change that negatively impacts those with a protected characteristic more than other employees, this may be indirectly discriminatory, and in such a situation you would have to, as an employer, show that the change was objectively justified, meaning there was a proportionate means of achieving a legitimate aim. So that's a key point to keep in mind if you are thinking about this route. So now I've just popped up some of our key points and takeaways from today. So as mentioned, it is very important to firstly use the correct consultation procedure, whether that is for redundancy or changing terms, and they should both be started in good time. Always listen to your employees, even if ultimately you cannot accommodate their views or their suggestions. It's always important to take them away with you and investigate them, and then come back to them with a response. Always consider the alternatives, and not only just consider them kind of in meetings, but always document that you've actually considered them and why they weren't appropriate. And then lastly, have a clear business reason for your decisions. So again, it's one thing talking about the business reasons to the employees, but make sure that you have this in writing should it ever be challenged in the future. So that is it from Michael and I today, so thank you for attending. We do now have a short Q&A session if you do have any questions. But before we go into that, I'll just remind you that part 2 of today's webinar is taking place on Thursday the 14th of October at the same time, so 12 o'clock. So in that webinar, we will be focusing more on selection criteria, redundancy pools, the financial elements of redundancies, so what employees are entitled to, and how to actually implement redundancies and avoid the pitfalls. So we do hope you can join us for this one next month. But does anybody have any questions at all for Michael or I?